Hello, in this video, we will review 42 CFR Part 2. As social workers, our primary goal is the safety and confidentiality of our clients' private health information. Most are familiar with the Health Information Portability and Accountability Act, or HIPAA. However, within the United States Code of Regulations lies additional protection for people in treatment for substance use disorders. In this video, we will review the ethical principles of confidentiality, the barrier of stigma, and learn about the 42nd title within the Federal Code of Regulations. Confidentiality refers to boundaries surrounding the sharing of private information between social workers and clients. The National Association of Social Workers Code of Ethics identifies the importance of confidentiality in the ethical responsibilities to clients. Confidentiality is of the utmost importance when working to build the practitioner-client relationship and in empowering our clients to make informed decisions about their care. While important for our clients' self-determination, confidentiality is also directly linked to stigma surrounding some medical and mental health conditions. Stigma is defined as negative social meaning placed on individuals, such as an individual being incapable of thinking for themselves or living independently, and in the case of substance use, an individual being incapable of making morally good decisions. Specifically pertaining to the topic of 42 CFR Part 2, the stigma of engaging in substance use treatment has protections in addition to HIPAA. Seeking treatment for substance use disorders is complicated by societal views that having an addiction is a moral failing rather than a medical condition. When it is known that an individual is in treatment for a substance use disorder, this can cause discrimination when seeking medical care, in legal proceedings, and even within an individual's family. While such discrimination is not legal, it persists and can result in life-threatening consequences. Stigma deserves a presentation on its own, however, that is not the focus of this video. Next, we will relate how stigma resulted in developing 42 CFR Part 2. Drug laws have history dating back to the colonial period. However, laws developed in the post-war era began to shape our current legislation. Beginning with the Narcotics Control Act in the 1950s and followed up by Nixon's Comprehensive Drug Abuse and Control Act in 1970, punitive action superseded a focus on treatment for individuals with substance use disorders, which persists today. In 1975, as an effort to lessen fears of incarceration or discrimination for individuals seeking such treatment, the United States enacted Title 42, Part 2 of the Federal Code of Regulations. This regulation strictly prohibits release of substance use treatment information unless explicitly identified otherwise by the client in writing. 42 CFR offers limited exemptions for sharing such information, such as sharing only medically necessary information during a health emergency, or sharing only information specifically identified in a formal court order. This means that if a lawyer reaches out to a practitioner in a substance use treatment program asking about a client, even acknowledging that the practitioner works with the client is a breach of confidentiality under 42 CFR Part 2. The client must sign a written release that meets 42 CFR Part 2 standards. Shown here and included as a handout is a sample release of information that meets the standards set in 42 CFR Part 2. This release of information must include the client's name, the name of your program, the individual or entity to which information will be disclosed, the purpose of this disclosure, limited to the minimum necessary amount, informed consent and a statement of revocation, date or condition upon which the release expires, the signature of the client, and the date signed. The interwoven concepts of stigma and confidentiality are represented in the Federal Code of Regulations under Part 2 of Title 42. In a practice setting, following the laws pertaining to confidentiality are of the utmost importance. Learning about the complicated history and intricacies of these laws will assist in understanding the purpose of why these laws have been put into place.